See, Chloe Hawkins is on the line. Can you hear me okay, Miss Hawkins?
Yes, I can hear you.
Okay, great. Just double checking with you. It looks like there was you filed a summons, and I just wanted to check with you to see if you had served that summons on the parents.
So I haven't. She's up in Lewis County, and I just got the paperwork yesterday, so I haven't had a chance to serve her yet. Um, I I Yeah, I need an extension on that, just a couple days.
Okay, so are you anticipating you'll be able to serve um, Miss Shawnee Bodish in the next few days?
I can serve her in the next few days. I do need the proper paperwork. I'm not entirely sure how to serve. As far as the father, Eldon, I don't even know his location, so I'm not sure where he's at.
Okay, there are a couple of different resources as far as service. You can go to washingtonlawhelp.org. That's a really good resource. And you can look under their family law or guardianship sections about service. Another place you can look is um, courts.wa.gov. And then that's actually, wow, I forgot. Hold on one second. It's got to type it. Yeah, it's a uh, www.courts.wa.gov
Okay.
slash forms
Okay.
and then
Okay.
look under there and there'll be some list different documents and forms that you can utilize for showing that you've served the other person and then filing that proof of service.
Okay. So, is it just all the documents that I turned in that I filed with the court that I need to serve to her at once, all the same time?
Yeah, the idea is that there's a notice and opportunity to be heard. So everything that you filed and that you're sharing with the court, you have to share that with the other party so they know exactly what you're saying and what you're wanting.
Okay. And then as far as the father goes, is there any resources for locating him or?
Um, one other resource you can use is the what's something called the Clear hotline, Clear CLEAR. It's a hotline staffed by licensed attorneys in Washington, and
Okay.
you can call them and chat with them, and they can give you some assistance. There are limited hours, so be aware
Okay.
of that. But the Clear
Okay.
hotline, you can find their phone number online.
Okay. Awesome.
So as far as the timeframes, we could look at possibly a 2 week set over to it need to be on a Thursday at 10:30. Uh,
Thursday. Okay.
so do
Okay.
you think that would be a reasonable time frame for you to
Yes,
start
absolutely.
that?
Yes.
Okay, 25th of April at 10:30. How does that look?
25th at 10:30.
Uh-huh.
I can make that work.
Okay, let's set it over to that date.
Okay. Thank you so much.
All right, thanks.
All right.
All right, I'll turn the
And
Zoom
I
back
see
to
Miss
Bashor.
Farr is
Thanks.
present.
Good morning.
Thank
Mom's
you.
present too.
Mom is present. Very good. I thought we were looking for some orders on this one, I thought. Maybe I had my notes wrong.
Actually, Your Honor, there's some procedural things that need to be done in this case. The petitioner filed a standard petition, but it's filed under a different case number, so we need to consolidate the cases.
Do you know what that case number is off the top of your head?
I do. 8408.
All right, so we'll get those consolidated. Do you need an order consolidating those, or are we able to merge those? I'll work with the clerk's office and we can get that taken care of.
Then the other issue is the proof of service that was filed. The petitioner filed mother herself. My understanding is that mother is consenting, although I haven't confirmed that with mother yet. I did leave her a voicemail, but she hasn't called me back.
Ma'am, the old number, the 2508 is no longer a working number. That would be why I haven't heard from you.
The number I called, the last four was 2512.
2512. Oh goodness. Oh, that's my fiance. Okay. He almost never, I can give you a number to call. That's my number.
When this hearing is over, it'd be best if you just call me.
Okay.
Yeah, and then I
Okay.
can get the information from you.
Okay.
So as long as mother is accepting, I can send her the acceptance of service too, and that'll cure that problem. And then we can go forward and
Okay. And if I was observing, it looks like mom is agreeing to this. So yes, I think we do have consent essentially. So how much time do we need to get everything put together for?
I think about 3 weeks would give me enough time to talk with mother, get those forms filed and get my report in, get the final orders circulated.
Do we have a docket on that day? Because that's
What day is it?
on the 30th. That's going to be conference week.
Oh,
We won't have.
So we probably need to go 4, maybe over to the 7th.
that's fine, Your Honor.
Okay, so that would be May 7th. That would be at 10:30. So I'll just do an order extending and then I'll work with the clerk's office to get the consolidation between these two cases. My assumption is it'll go under the newer case.
I
Is-
did look at the case and it looks like the father wasn't listed, that's why it's a new case. You can
Oh.
like all of the parties.
Okay,
There's no father on the birth certificate.
okay, so really we just need to transition everything from this into that because that's the permanent one. Let me talk with Ms. Michael Buston. We'll figure out how we need to do that.
Okay.
But my assumption is that would be the one we'd want to do all the final orders in.
Okay,
But I will talk to her after docket today.
perfect. And Ms. Parks, you do have my number to call me.
Yes. Yes.
Okay, thank you.
Okay, so our next hearing will be May 7th, 2024. And if we can make a note, if worst case scenario, if we can at least have both of these cases on that day.
Yeah, I can put it on.
Okay, perfect. So we'll make sure we have both cases docketed and then I'll get the behind the scenes stuff to get it consolidated.
Thank you.
All right. So that'll be all for that one today. And then ma'am, if you can get a hold of Ms. Farr, she can walk you through what else needs to be done.
Yep. No
Ms.
problem.
Powers, good morning. Okay, great.
Good morning, Your Honor.
And let me see here. So where are we at on this case? I see Ms.
Well,
Turner.
we're still here on the show cause hearing. Michael Trotter has appeared at the last 2 hearings and indicated that he would be representing the mother, Patricia Havens. To date, he has not filed.
He's just coming in right now, so.
Okay.
So I think Mr. Trotter did.
Yes, Your Honor.
Good morning.
Yes.
Hours, if we want to go ahead and bring everybody up to speed where we're at.
Thank you, Your Honor. We're here on the show cause hearing. We were here on March 26th, and at that point, Mr. Trotter indicated he'd be filing a notice of appearance and a response for Patricia Havens before today's hearing. We still have not received a notice of appearance or a response, so we don't know what the mother's position is. It looks like the alleged father, Ty Clapp, might be present. He also has not filed any pleadings. Mr. Turnbull was appointed as the guardian ad litem. I don't know where she's at in her process, but we would ask at this point that the court extend orders and set this over as long as Ms. Turnbull needs to be able to finish her report. And once her report is finished, I'd like to set this for a hearing.
All right. Mr. Trotter.
Yes, Your Honor. Yeah, I would agree. There's some things we need to work out on this end. And so I would, I know my client anticipates we'll file an objection. We just haven't been able to do so at this point. So I think extending this would be appropriate.
Are you representing both parents?
Ty and yes, correct.
Okay.
Can I ask when a notice of appearance will be filed?
Well, it should have been filed. So it'll be filed as soon as I'm off of this call, of this meeting, this hearing.
Okay.
Immediately. Sorry about that.
Let me just see here real quick. I see Miss Havens. Let me just double check it. Open up my screen a little bit. And ma'am, you're agreeable to that at this point? Miss Havens?
Mary Havens is my client, the
Oh,
petitioner.
I'm sorry. I'm reading the wrong line there. I apologize.
Thank you.
So Patricia Havens I see Mr. Clapp is present. And
This, Patricia and Ty often appear together on the same
okay.
Zoom.
All right. So Mr. Trout, I'll assume that you, based on your representations, that you have the authority to proceed. So how much time do you think we needed to get for Ms.
Yeah, I'm hoping I would have liked to have had it done. So another 2 to 4 weeks.
Ms. Turnbull, what's your timeline look like?
Yeah, I think I could have my report completed in about 3 weeks. So
Okay.
that
3 weeks, we don't appear to be having a docket. That's judicial conference, so we won't have a docket. So I could go to the 7th of May. Is that a workable day for everybody? That'd be
Yes.
4 weeks out.
Yes.
Okay, so May 4th. It'd be at 10:30. And Ms. Powers, do you want to do up an order on that one?
Yes, I'm happy to do that. The orders that we've had so far give the parents visitation Sundays at 1 p.m. I will just include that in the order going forward as well.
Very good.
And I just had one concern to see if we could try to address, if at all possible, would be the visitation. It's difficult. Clients have expressed difficulty making the 4-hour journey. So I don't know if there's a possibility the parties can try to meet midway or something. I'm open to ideas.
I'd ask at this point that we leave it the way that it is. My client is returning to work and is doing full-time care for this newborn infant. And the only responsibility the parents have is to come to the visit once a week. So hopefully the GAL may have some information about visits, but at this point we'd ask that it stay the same until the next hearing.
Turnbull, do you have any thoughts on that or status quo?
Well, yeah, I would say status quo at this point. I would agree with Ms. Powers in terms of the responsibility that's falling on Ms. Havens. I do appreciate that it is a long distance for the parents, but and
Okay.
That's
all right.
Yeah, they have not appeared for many visits that they were offered at this point.
Okay.
And I think asking Ms. Havens to drive and only to wonder if they're going to appear as an additional burden for her at this point.
So is this the one, just to refresh my memory, she is, just a second here. She's in Goldendale, that's right. And they were down, I believe, at the coast, maybe at Astoria.
Astoria. Mm-hmm.
At the point that we filed, the parents were staying in Longview. It appears that they're back out in Astoria. Yeah.
Okay. I think until I at least have a response and we see the visits happening at some level, I'll just leave status quo at this point. I'm happy to look at that as we move forward. If the parties come to some other agreement, obviously, the circuit court's not going to get in the way of that, or if Ms. Turnbull recommends something different in the interim.
Thank you.
Okay. So we'll set it 10:30, May 4th, status quo, and hopefully we'll be able to get at that point.
Yep. I'll make sure that notice of appearance gets filed immediately. My apologies. Thank you all.
How come you didn't? There was no objection there. You didn't object to nothing.
Well, my objection is that I made on the record. I indicated that we object, that we don't have all the documentation yet, and that I've objected as to the visitation with respect to asking for it to be midway. And those objections I made on the record, and they were.
I was never told. Nobody was told me about whatever the appearance thing. What is that? Nobody said anything about that.
About what? I'm sorry?
What's the appearance thing? You guys didn't say anything to me about that.
Appearance thing.
Or objection to her being there.
So, Mr. Clapp, this is Judge Bashor. It's a document that needs to be filed. It just simply is the official representation notification. what I would strongly suggest, sir, is to have you be in contact with Ms. Turnbull so she can get me some information so I can make an informed decision about how this case should move forward. Okay?
Thank you, Your Honor.
You're welcome. All right, May 4th at 10:30, and I'll electronic copy the order's fine, Ms. Powers, and then we'll be back and hopefully we'll be a lot farther along in the case. This one, I had a number of documents that I didn't see until today. I don't know, looks like they may have been filed yesterday. So I haven't really had a chance to do a lot of calculation on these. So I don't know if you want to try and go through it today or.
If you want argument, I'm happy to give it to you, but it's also one of those things where I think if you look through the pleadings with, of course, your experience with child support guidelines and calculations, I'm confident that you can make a decision in chambers or at your leisure based on the information presented to you. Pay stubs are there. I think there's a decent synopsis from both parties in their declarations. Ms. Bliss is agreeable to it. I do want to just make a decision outside the courtroom today at your convenience. Or I can give you argument too. It's whatever court prefers.
My concern is when I try to add things up, I come up with completely different numbers than either of you have.
That's fine.
And I just run, I mean, and they're quite different.
Yeah.
So, and I'm not sure I understand. I started looking at these about 20 minutes ago. That's when I first got them. So I don't know if you want to try and do it today, or I can always set it over a week. And
well, how about you entertain real quick argument today? And if I want to set it over a week, I'm fine with that too. I just want this done. This is the only issue we have left. The parties have done the heavy lifting, which is the parenting plan, the adequate cost. We're in a real good spot with that. We just need some help on this child support issue.
Okay, Ms. Bliss.
And Your Honor, I would defer to your judgment. If you think having additional time to review documents and prepare for argument before Mr. Zandy and I proceed, I'm fine with setting it over 1 week. I do acknowledge that both of our pleadings were filed late. As you're aware, we did attempt resolution and got largely everything resolved. So this was the one remaining issue that in the 11th hour we realized wasn't going to be able to be resolved. So I'll defer to you if you want to proceed with argument today. I'm fine if you want to set it over a week to kind of review. I do agree that reviewing two very different child support worksheets, and then, you know, like you said, you came up with a different number on your own. So it may take reviewing it a little bit more in depth before we, you know, are able to reach a resolution, but I'll defer to you.
Yes, I'm just looking to what next week looks like, and it is pretty busy as well. I mean, I can listen to argument, I can take a look at them, and then if I'm unable to.
I'll be real quick. It'll be less than 5 minutes.
Okay.
And I think it is largely what it is.
Okay.
As noted, I do represent the petitioner, Justin Lindsay. Initially started on my client's petition to modify the existing parenting plan, which specified a joint plan across the board pursuant to work schedules. My client details for you that is changed some time ago. Parties continue to operate under, you know, the premise, the umbrella of a 50-50 plan until recently. It recently was back in the fall, and Ms. Lindsay decided, well, we need to change that. Thankfully, I think the big issue was that parenting plan, and that's what prompted this action to commence in the beginning. We resolved that. That's the good thing. Now left is this child support issue. I think the big thing once you have, I'll go through that real quick. These are just the things that I want you to be aware of, or at least take note of in your review of this case. First of all, you've got two employed parents. Now my client works at West Rock, where he's been for a significant period of time. He works not one of those 4-on, 4-off schedules that are pretty popular and common, in which there's shift differentials, there's overtime opportunities. He doesn't do that. He's a Monday through Friday guy. He works hours that are largely consistent, makes him largely available for the kids and their extracurriculars and time that he'll have. This is a week-on, week-off plan. The parties have agreed to that. It's a final parenting plan. There are no right of first refusals. It's right down the line. So there is no issues that could impact who's going to have the amount of time with the kids, or who's that could sway the practical amount of time in either party's favor. We don't have that. My client has given you his pay stub, which shows that he makes $29.18 per hour. Again, he doesn't have any of those bells and whistles or those added income producers, such as the shift differentials or overtime. We've calculated his month through March 17th. And if you look at his year-to-date totals, You'll see that's included. We arrive at a monthly net income of about $3,600 per month, $3,637 to be exact. What we're asking for you to consider again, and I think it's borne out in the information, the pay stuff that was filed under seal, is the fact he is paying union dues. That's $111 per month. He's also contributing to a 401k plan. That's $366 per month, which again is under the $417 credit the statute affords him. He's also paying, which is considerable, medical, dental, and vision under a family plan. If you look at the information, it shows that he's paying over $700 per month for that. And we've given a credit which understates the actual cost of $90 for the kids' portion. If you calculate all that, again, I think it backs up to come very close to what we've calculated his monthly net income at. There is a loan that's coming out. We didn't quantify that, which is the 401k loan. It's minimal, but still nonetheless, that is part of his pay stub. You'll see that's about $263 per month. So certainly under the statute, he's entitled to claim the union dues. He's entitled to claim the medical he's paying for the kids. He's entitled to pay the credit for the 401k, provided it's less than $417 per month, which it is. And we're just asking you to take account of that. If you look at the mother, in this case, Ms. Lindsay, I think it's largely agreed, or pretty close. We've arrived at a net income of $2,911 for her, which again is reflected in the worksheet. I don't see any red flags as to potential assets or potential income streams that are coming to her outside of what's detailed in her pay stub and her tax records. Run those numbers. And again, these are two parties that are within 5% of each other on line 6 of the percentages. It's a 55-45 split. And you're going with an exact 50-50 parenting plan on a week on, week off. Certainly, and it doesn't seem disputed, my client is entitled to the overnight residential credit for that 50-50 plan. And again, that seems to be agreed. Now, that would result in my client paying about $50 per month for the kids. And that's what we're asking. So we're asking you to adopt our worksheets as it relates to this. Final issue, again, is this after school program. This has been an area of contention for these two since last year. This is what prompted the state's intervention on the child support, saying my client was in arrearages. We detailed that for you in my client's initial pleadings in his declaration. These kids have long since gone to the Longview Parks and Rec after school program. My client's usually home by 4:30. The kids are at the program for about an hour a day, give or take. Mom has used this service in the past quite a bit too. Both parties have agreed. And again, you see the text information between them filed in my client's initial motion that says, okay, if you're not going to pay child support, then you pay the then $310 per month along with Parks and Rec. My client's been doing that. But nonetheless, if we're going to put child support in place, especially as moms is suggesting, we're asking for the after school program to be split according to those percentages of incomes on line 6, which is that 55-45 split. So either way, that's kind of what we're at on this. Kids are doing well in that program. They enjoy it. My client details for you that there's kind of a care aspect of that as well. The kids are allowed to go out and exercise, play games, do those types of things. And that seems largely beneficial until mom or dad is available. So we believe that falls under the work-related daycare because that's essentially what it is, what it's traditionally been used for. And we're asking again that be split according to the percentage of incomes, regardless of what you do to the transfer, if any, child support.
So can you, I guess, and I'll hear from Ms. Bliss in just a second. There's a difference that you've got in her income of about $150 net income. And I'm not sure, I'm trying to figure out where that's, looks like there's an income tax. Maybe that's it. Looks like that's different.
And I think for her, is we simply took her 2023, and while council's making her pitch, I can certainly run the numbers again. I think we simply took her 40,728, divided that by the 12, which gets us to her gross, took out the standard deduction, which takes us to a net.
No, I understand that, but there's you're $150 apart on the taxes.
Correct.
So do we know how yours was calculated?
I'm sorry?
Do you know how yours was, how you came up with the $70?
No, I think it was just, you take the 40,000 and change, divide that by the 12 months, get the gross, and then the computer will take out the standard deductions for taxes, retirement and the like. I don't see that she's retired, contributing retirement. council can correct me if I'm wrong. She's got her Medicare, she's got her workers' comp, she's got the Social Security, she has those types of things, which are the standard deductions, and of course the taxes. So the computer will run that accordingly.
I understand that, but they're $150 up on the two worksheets on the taxes. So do you know how yours was calculated?
That's how mine was calculated.
No, you know what the
single, each claiming one.
Single,
Yes.
each one. Okay. Okay.
All right. I misunderstood the question.
Okay, that's what I'm trying to understand. Why is there a difference?
Yeah, single one.
Okay, so Ms. Bliss, let me hear what your side of this is.
Thank you, Your Honor. And for the record, I do represent Stephanie Lindsay in this matter. In looking just frankly at the pay stubs provided by both Mr. Zandy and myself, we both provided the same pay stub for Your Honor. My income calculation was based solely off of the year-to-date income of Mr. Lindsay. As the pay stub shows, as of March 22nd, he had earned $15,083.62. Being as that wasn't a full month, I divided that by the 2.6 months to get to that $5,801.39 that you see in my gross income for him on my child support worksheets. I again took the deductions that were present in his pay stub, divided that by the same 2.6 months to get the amount for his deductions. I think mine is very cut and dry. I think that's a lot more reflective of what his actual income is. Even if you look at the year-end W-2 filed by Mr. Lindsay earlier on in this case, that was a $67,773. Divide that by 12 months. That's still a $5,600 gross. So I think to suggest that he's only bringing in $4,700 when the pay stubs and the W-2s reflect a completely different and frankly greater amount, I think is disingenuous. And I do ask the court to pay specific attention to what he is actually bringing home. I acknowledge that he claims he makes the $20.19 an hour, claims that he doesn't have any overtime, but his wages prove otherwise. As you can see, he has earned significant money already this year. Those figures need to be considered. What Mr. Zandy is attempting to have you consider is not only a reduced gross, but also include inappropriate deductions. He's asking you to include that 401k loan, which is not appropriate. I acknowledge that he is contributing to a 401k. That's also present in my worksheets. What hasn't been provided to date until this documentation is that he was providing medical insurance for the children. In Mr. Zandy's first child support worksheets filed earlier, when this matter was filed back in April, or in February, excuse me, that wasn't included. This is the first time he's ever acknowledged that he may or may not be providing medical coverage for the children. The children are on state medical coverage. So if he is providing medical coverage for the kids, obviously that's appropriate to be provided in the worksheets, but we haven't been provided any documentation to that. So again, this was kind of a last minute preparation for both Mr. Zandy and myself. I understand that it takes time to prepare that documentation or to procure that documentation from Mr. Lindsay's employers. We just frankly have never heard that he is providing medical coverage for the kids. This is the first that we're hearing of that. So I think the income calculations are pretty straightforward. There's not a whole lot of difference between my client's information on both Mr. Zandy and my worksheets. I did note that there was about $150 difference in the state income tax section. Again, I don't know if that was obviously hearing Mr. Zandy say that he had it as single and each claiming one provides a little bit more clarity. When I run the calculations, I do single at 0, neither party claiming any children, because obviously that's borne out in the child support order. However you decide to do it, I don't think there's a huge difference between my client's income, but the biggest issue is Mr. Lindsay's income. That's about $1,000 difference gross. And I do believe that my worksheets are appropriate based on both the current income information that we've been provided and the historical information. To claim that he's earned $4,700 gross is just frankly not bore out by the evidence provided to you. So I do believe that our worksheets are appropriate. Again, if documentation can be provided to substantiate that he is providing medical coverage for the children, obviously I'm happy to add that in there as well. But prior to receiving this current declaration and worksheets, that's the first we've heard of it. As it relates to the after school program, I didn't realize this was an issue, obviously, which is why it wasn't addressed in my client's declaration. My client's of the position that each party should pay their own after school or daycare expenses. They do share a joint residential schedule. It's my client's position that the children are no longer going to this after school program while in her care. So Mr. Lindsay is essentially the only party that's going to be utilizing this service. So we are asking the court to order that he pay his own expenses on that. Lastly, in our declaration, we did ask for a contribution to attorney's fees. Again, given the disparity of the parties' incomes, if you take our calculations, it's about a $2,000 difference. My client did prepare all of the initial and final orders in this matter. Again, the parties spent significant time attempting to resolve this matter by agreement. That failed, but my client did expel significant attorney's fees in order to resolve this issue. So we are asking for a contribution of fees in the amount of $1,000.
Okay. Ms. Sweeney, I see you're involved in this case. Did you have any comments?
Your Honor, the state's interest is only regarding the medical coverage for the children. So we would just ask that use as accurate income information as we can to establish the percentages for responsibility on those, as well as that the order, if we have one, the results today would reflect that the children are on state medical through the mother.
Okay. So I assume if the parties prepare an order, they can run it by you for approval?
Yes, that would be our preference, Your Honor.
Okay. So I guess I'm still confused. I mean, we're different on the taxes. I come out different than either of you do. And I'm looking at the same pay stub. We got 3 different numbers to calculate out. And I'm not sure how that is. One's, I mean, I'm not sure how to fix that. Because I don't know how you calculated yours.
Well, so you go, here's where the single one comes from. On the existing child support order back from October 26, 2020, paragraph 18, every year, Justin claims Cameron and Stephanie claims Olivia. So you've got that for each single claiming one comes from.
Okay.
So that's going to make a little bit of difference. And then if you look at it, again, it depends on if you're going to take the year to date, if you're going to take the hourly rate, or how you're going to do that. And there's different ways to skin that cat, but that's, I think, where the difference comes to. Small difference, but a difference nonetheless.
Well, it's $1,000 on the gross.
On the gross, but if you look, you got to consider too, that part of 2023 gets carried over to 2024.
So where does that show up?
But you don't show that, but that one comes out if you look at the last pay stub of 2023, or you look at the first pay stub of 2024, it's going to show you what the year to date is, because there might be 3 or 4 or 5 days due to the pay periods that occurred in 2023 prior to the change. So that's going to be included in the gross year to date incomes, which is why in this case, it's probably easier just to take the hourly rate. And, you know, to piggyback on counsel's arguments about overtime, if you look at his pay stub, he's got very little overtime. There's next to nothing with that, which again is consistent with his declaration. So I think the difference between the hourly rate and the year to date rate is based on you had some carryover from 2023.
Yeah,
Which is not uncommon at West Rock, it's not uncommon at warehouse or depending on
right. Yeah, I understand that was not pointed out previously, so I wasn't aware that was. I mean, that impacts probably the calculation I did.
I think it does, yes.
Okay.
You want a brief rebuttal or are you good?
Sure, go ahead.
Well, I'll start with the easy one, and that's the attorney's fees. Again, we're in this position because mom decided some time ago that she was going to basically stray from the agreement they had last spring, which we provided you the text messages that state my client will pay the then $310 a month in lieu of some child support. She says that's fine, we'll give you that text communication. Later says not only am I going to contact to take your back support, oh, by the way, because your schedule changed, I'm no longer going to abide by that joint plan. And so we're here largely because of mom's actions. I think if anybody would be entitled to fees and costs, it would certainly be my client who can make that argument. Again, the medical is what it is. It's borne out again in the pay stubs. The kids get medical insurance cards to suggest that Mrs. Lindsay had no idea that the kids were covered for my client's plan. Again, it's disingenuous. Could have provided you that information. We just got Mrs. response last Wednesday. And I turned around and replied in less than 48 hours. On Friday, it was filed in. And so given the fact that it was less than 2 days to file a response, that becomes that issue. My suggestion on that is we get the information from West Rock that's easily attainable. You can give us some direction on which way you want to go with that, and I'll plug that into the worksheets, and we can all, it sounds like we're agreed that belongs. The only question is what's the amount. So I think that's an easy fix. That too will tweak with the transfer if there is any to some extent, but nonetheless, I agree with Ms. Bliss that we could probably easily discern that once with more information. After school program, that's a benefit to the kids. That's a benefit to both parties to suggest, well, each party essentially pay for that. When they use it, you can't, because both parties have traditionally used that. Both parties agree that it's after school care in a mild, moderate extent, but nonetheless, there's a benefit to the kids for that. So I think the statute is on point that any after school care is to be split according to the percentage of incomes. That's what we're asking for that. Alternatively, if you want to order my client to pay the entirety of that in lieu of the child support, I don't think he has any dispute with that. But again, it just comes down to preference of which way the court wants to best address that. Those are the issues. I think they're all easily manageable and workable. But nonetheless, we are asking you for some input because the issues that the court is asking us about are largely the same ones you're on.
Okay. Well, to avoid having this thing drag on in additional hearings, let me just do it real quick here. So I'm going to still have you, and I think what I'm going to do instead of ordering any attorney's fees, I'm going to give you some numbers to have Mr. Zandy have your office prepare final papers on your client's time. Okay. So I'm calculating his gross income based on his hourly at $5,019 gross, and that's just based on his wages. That's the highest wage he earns, and I'm assuming that's
2905.
It's 2918.
I'm sorry, 2918.
Yeah, times 40, and then multiply that out. Times 4.3 comes to $5,019 rounded. I don't have any. I guess there's a little disagreement on her income. It sounds like the gross looks the same. My only question is they should both be using the same tax calculation out of support calc, and I don't know which of these is using which. If those two numbers off Mr. Zandy's both are single with one, and that's different than what Ms. Bliss used, and I just don't know that because I don't know what those taxes work out to. But he should have his union dues, as should she. I'm not going to grant the 401k loan payment, but he does get the 401k contribution. And because really the only difference I'm seeing on her income is that tax calculation. So I guess Ms. Bliss, if you want to rerun your support calc with that setting specifically, and you can verify if you both come up with different, one of your programs is not current, then it's my assumption.
Yes.
I mean,
What happens if they change them regularly?
they update the tax table. So
you want to use the same for her then hourly rate times 40 times 4.3 or what?
I thought your grosses were the same.
They were the same.
Okay, so
Yeah, I'm fine with the gross. I just don't know if the tax is correct. If the tax is correct at the 270, what's she doing it at 237, which seems unlikely since his is at 305 or several thousand more. But again, I probably just need to run the tax number. Everything else looks fine. The 318 401k, that appears to be what I saw in his W-2 basically. And then if what I saw in the W-2 was a fairly significant contribution towards health care of some sort, and it looked like that was by the company, but I don't know if that's something he pays or the company pays. So that you just need to have some verification of that. If he's paying it out of pocket or out of his deductions, and he should get a credit on that.
So that'll go for kids.
Right. If it's just, it'd be just for the kids only. Yeah. But again, looking at the W-2 that I looked at, it wasn't clear to me that that's coming out of his paycheck or if that's coming out of the company paycheck. I assume they're paying some portion.
You look at his pay stub, that's where that $700 a month that he's paying out of pocket. It shows that is the employee contribution towards the healthcare. Okay. Which is a lot of money, but then again, it's not surprising in this day and age.
There was also what it looked like was a healthcare savings
plan. Could be an HSA or something too.
So, yeah, which may or may not. So if you want to rerun those numbers, then whatever comes out of that with the standard standard credit for the 50/50 plan. Okay. And then we're not changing tax exemptions. That stays as it was, I assume. And then as far as I don't know what that number is going to come out to. Your number had it at 50. Yours was at 200 and something. So I don't know where that's going to come out. As far as this after school thing, I guess my inclination there is that they each pay according to the worksheet on that. He pays whatever the child support calculates is, and then split that according to the plan.
Share the after school program.
Yeah. Mm-hmm.
Yeah.
And then the order should go over to Ms. Looney's office for approval on any language the state needs in there for their purposes.
Include the standard medical language, Ms. Looney's agreeable.
And then just include that the children are on state medical with mom.
Yep. Okay.
Okay. And
our date, can we just call it May 1st?
We both requested April in our pleadings.
That's mine.
I think April 1st. It's been going for a while.
Okay.
All right.
Okay.
Presentation in 2 weeks, or when is judicial conferences?
That is a judicial conference. Well, wait a minute. No, that's
That's the week before.
2 weeks would be fine. 23rd.
23rd. Okay, I will run you worksheets with that information and get you what I can for medical as soon as possible.
Okay. Just on for review of filing
Perfect.
the report.
Thanks, Judge.
You're welcome.
Correct, Your Honor. And my report is not completed. I came across a collateral witness that I was not expecting here within the last couple of weeks. And she was to send me some documentation that has not occurred yet. And so I need to speak to her. And then I'd like to speak to the parties about the information that I received from this collateral contact. So I'm asking for about a 3-week set over.
Give me just a second. I believe that Miss Lee is still trying to join.
I believe his counsel is Faye Brightreed, and I don't see her either.
My understanding is she withdrew a month or two ago,
Yeah, there's a notice of withdrawal from Miss.
February 6th, it looks like.
Yeah. Correct. So the only problem with 3 weeks is there will not be a docket in 3 weeks. So I could go out 4 weeks if that works for everybody.
That would work for me, Your Honor.
Fine with that.
Okay, so we'll reschedule this for the 7th of May at 1 o'clock.
Very well. Thank you.
At least a
Thank you,
couple
Your
of
Honor.
times, I think.
Welcome.
So where are we at on this?
Yeah, thank you, Your Honor. This is our motion to stay the enforcement of a forced sale of 2 properties. Just call them Jim's View and Dusty Drive to make it easier. We sent it over, attempting to try and seek resolution with opposing party. We weren't able to get there, so this motion is on for our motion to stay the forced sale.
So your request today is just simply to stay that order? Is that what I'm hearing?
Yes, Your Honor. We had made a CR 60 motion in December to vacate judgment. That motion was denied, and it's currently on appeal. So the provision of the final order allows for the wife to force the sale of properties that were awarded to Mr. Cutler as a separate property in order to satisfy the money judgment. A special master was assigned, and some documents have been signed by the special master. We're asking to halt that sale currently, as we think that will cause irreparable harm to my client, Mr. Cutler. It'll be removing his only home, and it'll also be affecting the homes of his 2 children and their families. And the basis here is there's no real harm either to the wife in this action. She has a current vested interest in both properties. Her name's on the title. So if anything, pending the appeal, her interest in these properties and these properties are potentially going to continue to gain in value, and therefore her interest is going to gain as well. So for those reasons, Your Honor, that's the basis for our motion.
Question for you. It looked like the property, and I don't know if this is disputed, the total property involved is about $500,000 in value. Is there improvements to that property? Like a building?
Yes, there's buildings on both properties.
Okay. And are they insured currently?
Yes, they are.
Okay. All right. So let me hear from Ms. Rustin.
Thank you, Your Honor. So, I mean, our response is pretty basic. I know both sides kind of went into some what we might call, emotional arguments as far as who's suffering financially and who's not. But I think really what it comes down to here is, number one, is there a grounds for the stay under statute, court rule, local or state court rule? And we would submit there's not, number one. Number two, even if there was grounds for the stay, the appellate rules are pretty clear that a supersedis bond is required unless they get court permission otherwise. And so the issue that we have initially is when I got this motion and we put in our materials, I did notify Mr. Hunter's office that the bond is required, and was trying to give him a heads up that would be required before the court could do a motion to stay, especially when you're trying to avoid the enforcement of an underlying money judgment that also affects real property. There's a money judgment for almost $370,000 in favor of my client that's already been accruing interest for over a year. My client also has a judgment for attorney fees. And so the supersedis bond is a prerequisite to getting the motion to stay granted, unless, like I said, the court grants something alternatively. So the rules that were cited don't even give rise to a motion to stay. They cited 52B, which talks about amending findings. They cited 59, which is for a new trial and is required to be filed within 10 days. They cited CR 60, which is under a motion to vacate. And then they found 62B, which 62B allows a stay of enforcement so long as there's a 59 or a 60 rule motion pending. So that doesn't even apply here. So we would submit there's no underlying substantive legal grounds, but like I said, procedurally, the supersedis bond is required by Rules of Appellate Procedure 8.1. That's not been posted. They've not given any reason why they've not complied with that court rule and that appellate rule. other than I think they made some kind of veiled statements in their materials that she has other recourse and she has other protection. It doesn't matter. I mean, that's not, it's very clear in this case. So we are asking that the motion be denied. We are asking for an award of attorney fees, because like I said, the supersedis bond is a step prerequisite to even getting the state granted. And would just ask that the order be denied at this time. I think our materials are pretty clear. If Your Honor has any questions, I'm happy to answer them.
I'll respond.
I'll go ahead in your response.
I'll make it quick. I appreciate counsel reminding me of a few points. As for on the issue of the bond, no court has actually made a determination of what the bond should be. I think that's at least in front of the court now. I know opposing counsel has put up some numbers and requested a supersedious bond. And we'll submit that really what we're asking for is an order to supersede without bond. And the basis for that is in the rules under Rule of Appellate Procedure 8.1 F. It allows the court to basically just file an order that it's superseded without a bond, especially if there's a decision affecting property. And especially if the property has a value which may fully or partially secure any loss. That's 8.1 C2. So that's what we have here. The opposing party has a vested interest in these properties. So and it would cover any potential loss she may experience. And as for the basis of the motion, we are basing this on CR 62B, which allows for relief of judgment pending the disposition of a motion under CR 60. And that's what we're arguing. This appeal is a motion under CR 60 that's being appealed. So pending that disposition is the basis for our standing. And also there's a sort of a catch-all under CR 60C, where other remedies, the rule doesn't limit the power of the court to entertain an independent action to relieve a party from a judgment order or proceeding. So basically, essentially it just comes down to my client's going to be put essentially without a house and his family as well. And on the other end, there's no real justification for why this needs to happen. Why it has a vested interest. She vaguely claims about some financial hardships, vaguely claims about how this procedure is affecting her marriage or her work and employment, but it's not real clear exactly. It's a lot of telling and not a lot of showing. So,
Okay. So, Jim, looking at the decree in this case, which I assume this is one from April 11th. This is it's a judgment for $367,500 and then a $5,000 fee judgment. And then there's was there a deed of trust put on this property under number 20?
We didn't pursue that because of the cost associated with recording it because my client was still on those deeds. So.
Okay. So that was purely as security, correct?
Correct. That was correct. That was nothing acknowledging that the debt's already acknowledged in the decree itself. That was simply in case we needed security.
Okay. I guess I'm trying to looking at this order. She just wants to get paid, correct?
Oh, ultimately, yes, that would be ideal. The recourse, it's two kind of multifaceted. So number one, he was required to refinance or otherwise remove her from the two property mortgages within 90 days. He didn't. He also does owe her the money judgment, but the recourse on that is interest. I mean, my client realizes that. She knows that there's no deadline to pay it. It just keeps accruing interest. But that is secured assumedly by, not assumedly, it is secured by the properties. And so that's kind of the domino effect here, which is she has this money judgment secured by the properties. She also has the right to force the properties to be sold if he didn't otherwise remove her. The 90 days was up last July. So we're almost at a year past when he was supposed to remove her. And she waited to try and see what would happen and nothing happened. So I just think that, I mean, notwithstanding any equitable arguments that Mr. Cutler might make, I
Did you call 811?
All right, we had a bit of feedback there.
Notwithstanding any arguments he's making, it's just I mean, I've never had someone file this without pursuing the bond. Now, I guess they can read that argument, or they can read that section of the rule that talks about when a party's not required to post a supersedeas bond, but they're skipping a step, because in order to get permission not to post a bond, that has to be court ordered, and it's for a very, very limited number of reasons. So it's pretty clear to me that you can't get the stay without posting the bond as a condition precedent. That's our position. So the bond would be posted in case something happened where, I guess what the court or what the rules are considering, because they do tack on interest and attorney fees and collection costs. I guess if he spent everything he had pursuing the appeal, the bond would be to then secure my client against something. I mean, I think that's the purpose behind it. So just saying that she has security because she's on the title, well, that's a little different than liquid assets from which to satisfy the money judgment. So that's where we just disagree on that kind of factor.
If I may, Your Honor, in short.
Yeah, go ahead. I'm just trying to find the spot in the decree about the remove the. Go ahead.
Oh, I was just going to say that in terms of getting wife paid, Mr. Spencer has offered a couple of times with her working with him to try and refinance.
Your Honor, I'm going to object because settlement discussions are not admissible, and so I don't want to go down this path.
Yeah, whatever the parties have tried to resolve the case, that's not before the court properly. I'm not sure why this was put in here as far as removing her from liability. That's not typically done, but was that out of a court ruling, or was that agreed, or was that some of a default kind of an order?
It was a semi-default order. So, and a lot of the provisions of this, just to giving Your Honor a little background, a lot of provisions in this were done because of kind of how the case progressed. And I realized that Mr. Cutler is involved with his prior attorney and some stuff right now. But yeah, it was through a default order, and then at trial we put on a prima facie case just to establish values and to establish particular terms that we were requesting. And so that was through a trial with Pro Tem Commissioner Busby at the time. And then the orders were entered subsequent to that ruling. So, but they've already filed a motion to vacate. I mean, they filed a motion to vacate a year after trial, got denied. That's what they're appealing. I mean, so there have been multiple steps kind of to address this.
Okay, so this is a bit unusual, and the rule's not. I guess it's not at all clear to me, because you've got the money judgment with this, which this is. Under C1, it's also a decision affecting property under C2. It doesn't put any priority of how you handle those. But I mean, I think I'm not sure how you get. I'm not finding anything in here that would require a complete waiver of a supersedis. Mr. Counsel.
That for me, Your Honor?
Yes.
Oh, for waiver, that would be. Well, not necessarily waiver, but under Rule 8.1F.
I didn't.
I'm sorry. I think I realized what you're. C2 at the very end. It's the last paragraph, the last sentence of C2. It says, if the property at issue has value, the property itself may fully or partially secure any loss. The court may determine that no additional security need be filed, or may reduce the supersedious amount.
I'm not, you're not coming through clear, so I'm not following what you're. Could you repeat that with your 0.1, 2?
8.1 C2,
okay.
Last sentence says, if the property at issue has value, the property itself may fully or partially secure any loss the court may determine, that no additional security need be filed, or may reduce the supersedious amount accordingly.
I guess I'm not seeing that. I'm looking at the rule, and it says ownership of use of property. I guess you're looking at it under the alternate security of 1.
I think he's looking at C2. I see the same thing he's seeing. It's just that's just not what my read of the rule says, nor has that been my experience. I mean, meaning it talks about, so C is the supersedious amount. The amount of the supersedious bond, cash, or alternate security required shall be as follows. 1 talks about what it will be if it's a money judgment. 2 talks about what it will be if it's a decision affecting property and it's the money judgment plus interest, plus et cetera, plus the amount of loss which the prevailing party in the trial court would incur as a result of the party's inability to enforce the judgment during review. Ordinarily, the amount of loss will be equal to the reasonable value of the use of the property during review. So hypothetically, it talks about when one party is not getting the use of the property, how do you quantify that loss? And then what it talks about is the property itself can be a security against the loss of use. It talks about partially secure any loss, and the court may determine that no additional security need be filed or may reduce the supersedis amount accordingly. So this is the decision affecting property when you're talking about use of or the loss of enjoyment of that property. So it doesn't particularly excuse a supersedis when we're talking about property. Again, I don't dispute that the court, in the reading of this rule, that the court can make alternative arrangements for security, but the supersedis bond is where we start from.
Okay, well, I'm looking under B4. It does give the court some latitude in coming up with alternative security. She's currently listed on the property, so the property cannot be disposed of without her approval or signing off at this juncture. My concern would be, I don't know what that valuation of $500,000 exactly consists of, if that's mostly the land or if that includes the improvements. I guess my thought would be, for purposes of security of this, that Mr. Cutler either provide evidence that he has insurance, not liability, well, I guess both, whatever property insurance in an amount not less than $500,000, and that she's a payee on that. That would and he needs to do that within, I would say within, I assume that could be done within 10 days.
My client's sitting with me.
Couldn't quite hear that, Counsel.
Oh, my apologies, Your Honor. The microphone on this computer isn't so good. My client's with me, and he's indicating he can make that.
Okay. I mean, she's secured by the value of the property, but then this, in case anything were to happen to the property, she's a payee on the loan for up to the $500,000 or up to the judgment plus the interest that's due on it and any attorney's fees. So, I mean, I think that gives her, under the alternate security provision, it gives her the security because obviously the land's not going anywhere. If something happens to the improvements, she's going to be the payee under the insurance policy. So I think that would suffice. But I think there has to be something like that. I don't think you can waive the bond. There has to be some sort of arrangement under that rule.
And I would agree, Your Honor. I think it would still need to be, my reading of this is that we would still need to enter a decision that the bond is superseded without bond under 8.1F. And I think we could do that even after presenting the evidence of the insurance with Ms. Cutler as the payee.
So my thought would be is he should do that within 10 days. So we could put this on for review in 2 weeks to make sure that's been accomplished. If it is accomplished and counsel is satisfied with the result of that, if you've got an agreed order you want to submit, or we could use that for presentation as well on the 23rd. And if in fact he hasn't got that taken care of when we get here on the 23rd, then all bets are off and we'll need to proceed under the, he needs to either post a bond for the full amount to her, or I'm giving an alternative through the insurance and leaving her name on the property.
Understood, Your Honor.
Okay. We'll review it at 1 o'clock on the 23rd.
Okay.
And again, if counsel, if you all come to an agreement, have an agreed order, you can certainly just shoot that in ex parte and we wouldn't have to appear for that.
Okay.
Okay. Thank you, Your Honor.
All right. Thank you, Your Honor.
Your Honor, before we start with this, I'm the guardian ad litem, Karen Lawrence. What I have to say may impact what you are here to hear today. The mother in this matter contacted me on Easter Sunday, and I've been working through this week trying to figure out exactly how to deal with this. Miss Tenna's older daughter, who is 13 years old, I guess, goes to Monticello Middle School, or did until yesterday. She is now residing with her biological father down in Canby, Oregon, because she has made some very credible extreme claims against Mr. Olmos. For the fact that there are also smaller children in the home, this is very concerning. CPS is working on the case, but they won't speak to me because this is regarding a child that is not on the appointment, but there are small children in the house, and the teenager did not disclose this because she was concerned about what would happen to the younger children who are 2 and 4. I am told by Longview Police to suspend my investigation at this time because they are working on that. And so I can't do anything further. And there's a May 17th interim report that is due and a hearing for that. So I kind of am looking for what the court thinks we should do with this at this particular point while an investigation is undertaken by local law enforcement and Child Protective Services, and CJAC is also involved.
Well, I guess the only issue that's on for today was presentation of the order from 2 weeks ago, which I do have, does appear to be what I ordered. All of those are obviously concerning issues. They probably need to be brought before the court with an opportunity to respond to those.
How do I do that? We don't have any attorneys in this matter. Longview Police tells me to absolutely stand down and not do anything further. So should I just note it up for that?
You can certainly look at it. It'd be good to have something from the police if that's true.
Yeah, they're not playing real nice right now.
No, I understand that. As far as this order goes, and I did review through it, ma'am, did you have a chance to look at that order?
Your Honor, I was served some papers, but it was very sparse. Like it would go from like 3 to 17 to 5 to 17. And I don't think I received everything. I don't object to paying child support for my kids. I don't object to supporting my child at all.
Well, I'm just looking at this. This says the $50 per child and $100 total. So this says what I ordered. So, and again, this is separate and apart from anything else that may come out of this case. So my inclination is to go ahead and enter this today, because this does appear to be, and I did review through this based on the notes from the case. Let me double check one thing here. Yeah, so I'm going to go ahead and enter this. And then if there are some other issues we need to deal with, we'll be happy to entertain those. Okay.
What do I do? I
suggest you talk with Miss Lawrence if you got some questions. I can't give you legal advice. You may want to, either of you could appear here on a Monday. I believe we still have lawyers that are coming in and you can get some legal consultation. Are they still coming on Mondays?
Yes, 12 to 2.
Okay, from 12 to 2 on Mondays, we have some volunteer lawyers who can give legal advice. I'm just not able to do that. So I suggest we have questions legally that'd be a good time to do that. You can also call Northwest Justice or legal aid. Depending on circumstances, you may even be able to check with the emergency support shelter. They have some services as well. Okay, so I will sign this order that was provided, and then I'll wait for the next review. All right.
I will keep the court apprised of what's going on.
Okay, I appreciate that. Thank you. All right, so that'll be all for today. And then again, talk with Ms. Lawrence, as well as if you want to get some legal advice on Mondays, 12 to 2.
Thank you.
Okay. I've signed that order.
Thank you,
Your Honor. Good afternoon. Let's see, Mr. Foreman is present here. And I just double check something here because I had proposed orders that were in the court file in Odyssey, but I didn't see anything here like an original for entry.
Yeah, we had emailed them prior to the last hearing and we filed them, so I apologize. We didn't have like a hard copy delivered. And then on the last page of the proposed orders is the proof of service.
Well, I looked at the ones that were filed in Odyssey. They looked, for the most part, what I ordered. And I know there was, give me just a second here. There was, I know Mr. Gorman had filed when I look at it, I think it's really more of a motion to reconsider as opposed to something saying the orders are incorrect. Is that accurate, sir?
I would like you to reconsider, yes. Some of the stuff that I had turned in was a little after the fact, I think, but after knowing what I needed to turn in, I turned it in as quickly as possible.
Okay, well, if you want to have, there's a process to do a reconsideration. There's a process to do that. This is a presentation of the order that was entered. which are the papers that you should have received. Says here it's about 37 pages. I did look through them. I didn't go through every line because I didn't see a specific objection to anything in those orders other than the general reconsider the order.
There is one, Your Honor, if I could clarify for the court, it would be in regards to the parenting plan transportation. The parties since we are in court have agreed to a new location for transportation. And that was pretty far down in Mr. Gorman's objection, but my client does agree. So instead of his parents' house, they have a pickup at Food and Fuel, and then the drop off is at Safeway. So that would be an agreed change to transportation on parenting plan.
Is that accurate, sir?
That's neat, so that was always. And I had an objection about the section 8B there, where I was, because I don't plan on living in that trailer forever. There's not enough room for my kids and myself. It's adequate for temporary purposes, but by no means do they have enough room to be by themselves.
Not sure what he's talking about, Your Honor. So he did put in his objection that the pickup and drop off are the two, and we're just informing the court that we agree. It's Food and Fuel and then Safeway. And then I believe his other objection, which is pretty far down, is he states I love my kids, but I don't know if I was awarded Tuesdays. And again, I'm not sure why he's raising that objection because we don't list Tuesdays on the parenting plan. So he was objecting to having Tuesdays, but there's no Tuesdays on section 8B.
It's not what I was objecting to. I just saw it was on the parenting plan. And I was asking if that was, because I didn't see that for the order to begin with. So I was asking for clarification to that effect.
So I guess,
Yeah, I think what he's saying, Your Honor, is after the hearing we had offered Tuesdays, and then part of his objection was, I love my kids, I just want to know if I was ordered Tuesdays, but there's no Tuesdays in the order because Tuesdays weren't ordered. It was just the every other weekend. So there's nothing there to object to because there's no Tuesdays written in the proposed orders.
Okay, just a second here.
No problem. Those are the only two things I saw in his objections that related to entry.
Yeah, and looking at the notes that I had, it was the alternate weekends, or the weekends, excuse me. I mean, if you agree to something different, you're certainly free to do more or less than that, but that's what the order was. And then if the transportation, yeah, this had his parents' home, so you want to change that? You're agreeable to that?
To that, yes.
Okay. So counsel, if you want to forward some original orders with that change, everything else appeared to be accurate.
Okay. And Your Honor, would you like me just to send that to your JA for you to sign? We don't need to do another entry, do we?
As long as the only change is that the location for the transport, everything else appears correct.
There was one more, so the proposed orders as written, and this might be something you prefer Mr. Gorman and I to work off docket so you can get onto your calendar. The orders as written are what Your Honor ordered. My client was willing to change the child support order and change the mortgage payment order. Mr. Gorman didn't agree. So since that's not before the court, would you like me just to take it up with him? And if needed, she was trying to make it a little easier on it, but he still wouldn't sign orders. Again, not before the court, but she's willing to lower it.
But if you come to an agreement on a different number, I'm perfectly fine with that. I just signed what my order was. And then what I'll suggest, sir, I understand you're not happy with the order. I get that. You need to file a motion to reconsider that, then they can respond to that. And then I'll be happy to take a look at that. If you go to the website, there's some court rules on reconsideration. So, okay. And again, counsel, if you come to an agreement on the number change, I'm fine signing that as long as it indicates that's what the parties agreed to.
Okay. I can go ahead and, Your Honor, do you want me to resend all of the proposed or just the parenting plan with that transportation change?
Everything I've got is what's filed in the court file. So I don't have anything else.
Okay. You wanted me to send over though a new order with a transportation change? did you want me to just send over the parenting plan or send over the whole document? Or did I misunderstand the court?
Have any of the orders outside of what's in Odyssey?
Okay, so you'll be signing off on the orders in Odyssey, because they are agreeing to a transportation change.
I need to have actual paper orders that I can sign.
Okay.
The ones that are in Odyssey are filed already, and I don't have
Okay.
a enter those.
I'll send those over to your assistant right now, with the change for transportation.
Okay.
Thank you, Your Honor.
So those, I mean, you're sending hard copies or you're sending?
I was going to send electronic because I know Miss Warrington had indicated that we can send electronic, but if you want hard copies, I'll have hard copies either delivered this afternoon or tomorrow morning.
Well, original orders should be hard copy.
Okay, I'll have those delivered to you no later than tomorrow morning.
Okay, sounds good.
Thank you. Thank you.
You're welcome. All right, so I'll get those signed, and then you need to file your objection within 10 days.
Okay.
Okay.
Tiffany
That'll
Jensen,
be all
present,
done
Your
that
Honor,
one today.
for Ms. Fontes.
Good
morning, or good afternoon, Your Honor. It's William Ball for the petitioner.
Good afternoon. I think that we had a report filed by Ms. Height. Ms. Height, are you present with us here today? I'm not seeing her, but she did file a report.
Yes, Your Honor. It was just an interim report that she had filed with the court. So we're keeping in step with the court's sort of cadence on this case. And so I don't really think there's anything for the court to do today. There's no motion before the court. The GAL has filed a report. My client has been in contact with the GAL since the report to correct some inaccuracies and misstatements that she felt were included in there. I anticipate that those will be corrected in a final report. And from my perspective, for purposes of today, we've just checked in. The GAL is doing our job, and I think we can move forward.
Mr. Ball?
We'd ask so that the court adopt the recommendations of the GAL. Today is set on for interim GAL report and review temporary orders, which means to me that we're going to look at the temporary plan and would ask that the court just adopt what the GAL recommended, which is that father have parenting time every Saturday from 7 a.m. to 7 p.m. and then 1 weekend a month from Saturday to Sunday. That the transfer location be at the Target at Jensen Beach, and that mother to undergo a DV evaluation with collateral input from the father and other third parties. I'd ask that the court that we put that into a parenting plan as well.
Well, there needs to be a motion of some sort. I don't have the guardian ad litem here for one thing, but there needs to be a motion with an opportunity to respond to it. I just had this on to make sure we had the report in today. I was just looking back through the notes.
It does say review of temporary orders.
Well, that's my understanding too, Your Honor. I'm consistent with your understanding. And there was, once the interim report came through, there was an opportunity to review the temporary orders, but one of the things that was required before any review of the temporary orders was Mr. Stemmerman's DV evaluation, which neither the guardian ad litem nor I have had an opportunity to review. So even if there was a motion before the court to review the temporary orders, we don't have that prerequisite of Mr. Stemmerman's DV evaluation and compliance with any treatment recommendations. So I would ask the court to note that we appeared, that the guardian ad litem has submitted her interim report, and that any changes to the current order be brought by further motion or at some other point in time, because today's not the date for that.
Yeah, I need to have, if we're going to make some changes that aren't agreed to, there needs to be a motion with an opportunity to respond to those. So I just had it down today for review. I don't know where at the notes. Normally these are just to make sure we've got everything we got the Guardian reports in and we don't need to have an extension of the time for that.
Correct, Your Honor.
Well, I disagree about that. I think that we often change temporary orders all the time based on new information. There's not a motion necessary. And I think that the GAL order appointing the GAL envisioned the change or a review of the GAL report, and the court can make changes based on them. I'm going to file a motion, but I think it's another 3 weeks out. And
as I mentioned, my client has pointed out inconsistencies in the GAL interim report to the GAL, and she's not here, probably because this was just for a review to make sure that the report was filed. So we certainly would want an opportunity to respond to any sort of modification of the current parenting plan. And again, I mentioned that Mr. Stemmerman is supposed to have filed his DV evaluation and complied with treatment, and I have not seen any of that. So before any changes were made to the temporary order, and that is clear in the temporary order. So if Mr. Stemmerman has done that, Mr. Ball, please forward that along to me and we can take a review of it.
that's not the only restriction or the only limitation on changing the parenting plan. A lot of things could happen, and he has complied with the evaluation, but it's just not completed yet.
All right. Well, I'm certainly happy to entertain a motion with no parties have an opportunity to respond to it.
Okay, I'll set it on for that. Thank you.
Okay. There we go.
Thank you, Your Honor.
Welcome. Okay, got our screen back. I don't know what happened there, but so I have Mr. Roberts as president of court, and we are here for a number of items.
Yes. So first, let's take up the presentation.
Let me get to that here. Where did that go? So I did receive, I've got a bench copy of a proposed as well as an order, and this was the order from March 12th. And so, Mr. Roberts, I understand you're asking to have this reconsidered. I understand that. Yes. That's a separate issue. Do you have any objection that this order says what I did order?
For which,
this is the order of dismissal.
Oh, yes, I disagree on the order of dismissal because I have proof that Ms. Baldwin's been given all the paperwork.
Okay, that's a different question. My question is, does this piece of paper say what I said when I dismissed the case?
Yes, Your Honor.
Okay, so we'll start there. And I recognize you did file a motion to reconsider.
We can take that up next once you're ready.
In just a second. So I'm going to enter this.
Sometimes they're slow.
All right, so I had a motion filed. This was filed 3/11 to remove an improper form. And on the same date, a motion to require opposing counsel to produce evidence of substantiating allegations. And counsel, did you receive those two motions?
I did not. So as noted, we filed two declarations. The first noting that we didn't receive them the first time. The court, either last week or the week before, I think it was last week when we were before the court, you said, no, you have to serve them. Said, do it by close of the day. We waited. I directed my staff to, wait until, the clock strikes 4 and, don't close a second earlier. They actually waited after. He did not serve those on my office, didn't serve them the next day. We filed an additional declaration that just verifies we did not serve those documents. So as we sit today, those motions still have never been served. We were served with the motion for reconsideration. We were not served with these other motions.
Okay. Mr. Roberts?
I have the paperwork showing that she was served by the people. I even got pictures on one and when she was standing in front of Miss Baldwin's office to serve her these papers that I put in.
Did you file those already?
Yes, they've been filed. These are copies of the court, but these are statements from the people that delivered them. And
is that since we were here last?
Yeah.
Okay, because
Miss Baldwin said that she hasn't received any of this paperwork, and I've got proof that she was served. These are statements today that I had to go. That's why I was almost late today, trying to find it, get them. So I have some for Miss Baldwin. She was in here to give to her. I have copies of everything that was delivered to her. office.
When was that done?
Let's see. My friend Kevin delivered, it was 4/8. He delivered it,
That was
it was on office call 3/29. The other one was Angie Bolden, and that was February 29th at 3:42. And the other one was Gary, and my wife brought him down from Winlock, and he delivered him on 3/11. Excuse me, 3/20. I believe that's what I have here.
So let me ask you this. When we were here last
Yes.
week, correct?
Yeah.
And I indicated you needed to serve these on her office. So that would have been after April 2nd.
Okay, well, I misunderstood because she's already been served them. I got proof that she's been served them.
Okay. Well, I was real clear that you needed to serve those.
Okay, I thought I already had served them, Your Honor. I misunderstood you then.
Okay.
I thought you wanted me to prove that I thought if I brought proof that if she was served, that would be not.
Well, when we were here last week.
Yes.
So if you want me to look at those motions, I'm happy to do that, but she needs to, and she's saying she didn't get them. She's got her staff has provided declarations that they were not received since we were here last week, and then they were received prior to that. So I'm not able to go ahead on those motions.
Okay. So should I drop what I have at her office today? I have copies.
Well, you could serve her.
Okay. Well, I can't serve her, so.
You can't. Somebody else needs to serve
Okay.
her, and then provide documentation that's been done. And then we can have a hearing. But
Okay.
I can't do a hearing.
I'm sorry, Your Honor, I misunderstood.
Oh, that's okay. I understand.
I will drop them off.
And here's the problem, okay, is every time we keep coming back to court, they're sitting there not doing other stuff, and we're here for court, and you're here for court. I understand that, but there's a process of things, how they happen.
Okay, I had people serve her. I had statements that they served her. I had the court that I misunderstand because I thought the court stamped it. I came over here after they were served and had them put into the court. And
right, and I have those. I think I saw those. There's one for 329.
Should be three different ones, I think, Your Honor. Whichever one she's saying she hasn't gotten. And I have a copy of it right now, and I will have one of these people serve her right up front of her. I figured I just got papers served by her today. I don't even know what they're about.
Okay. I don't know what that is. So.
Yeah, I haven't even looked at it.
Okay, so those two motions, we're not going to move forward. I'm going to have you have somebody serve them, get somebody to sign a document they got them.
Okay.
At her office. So we don't have a question anymore.
May I ask a question?
Yes.
Which documents exactly has she not gotten? Which motions or orders has she not gotten?
I'm going to assume, other than the motion to reconsider, nothing. So everything that you want me to consider,
okay,
take them to her office, serve them, and we're going to need another hearing date. And every time we keep doing this, it's going to keep costing.
I'm just saying. I mean, I got a picture of. She took a picture of her cell phone with her card on it, Miss Baldwin's card, and that's when she served her.
Okay. Okay. Well, I have a declaration that says it didn't happen. So I got two parties, and I don't have them here that I can really have some kind of a hearing about that. So you'll need to reserve this.
Okay.
And my staff will always sign on the pleading itself. So if before he files it, if he wants to bring it, we can stamp it and note that we received it so that there's no question, and that's sort of can operate as a proof of service before it gets filed. We're happy to do that.
Okay, I'm sorry, Miss Baldwin. I thought you had been served. I really did.
So here's what I'll have you do, sir. Okay, just want you to listen. Take the documents you want her to get. Take a new version of that over to her office. They can sign they got and leave them a copy, and then file that one file the one they signed. That all know they got them.
Okay.
And then we'll be able to come back and have a hearing.
Okay.
You'll need to set another date on this, and I can tell you right now, we do not have court on the 30th, so it would have to be one of the other Tuesdays because we don't have court on the 30th.
Okay, whichever Miss Baldwin can do that.
Well, you'll need to figure out a date, and then she needs enough time to respond to the motions. Okay?
Okay.
And then
So
consider it separate. So, Ms. Baldwin?
So that only leaves the motion for reconsideration. Since the order has now been entered, that motion is right. I just asked the court to give me a week. I already have the response drafted. I just got to clean it up and get it filed to your honor.
That's fine. I think we put it at 10 days at least from our last hearing. So if that's going to be done within the week, then we'll just and these are things they're done outside of court anyway. So given all the things that are on my desk right now, I'm unlikely to get to it for a week anyway.
Fair enough.
Okay. I think that's all the motions. So you're going to need to reserve those, get them renoted. I'll look at your motion to reconsider once I have a response to it, and I'll be happy to get a ruling on that.
Okay.
Okay. All right. And sir, I'm going to suggest if you come here on a Monday from 12 to 2, there are some lawyers in the lobby. They can give you some guidance.
I've been trying. It's hard to get down there all the time.
Well, I'm just saying that's the best way for you to get some free legal advice.
Okay.
And I'm not allowed to give it to you. I've given you probably as much as I can. All right.
Okay.
All right. So strike all of those hearings today, and then I'll wait for a response on the motion to reconsider. Okay. And I'll reserve on all fee requests that were still out there.
And that matter is ready, Your Honor.
I got a lot of documentation on this today.
Your Honor, before we get in, I do have a preliminary objection to the reply declarations that were filed yesterday and today. The local court rule caps a rebuttal declaration at a total of 4 pages. These were 11 pages plus multiple exhibits attached. I received one yesterday and one this morning. I'd ask the court not consider those.
Brief reply, Your Honor.
Sure.
Yeah, so the motion to stay was filed in this case, and we actually have 3 different motions on here. The motion to stay is not really an ex parte order. It's not an emergency order. It doesn't follow under the court rules for what we use non-notice ex parte orders for. However, it was submitted. It was signed before I was even given notice. Because of that, instead of doing 4 separate 6-page declarations, my client decided to do one 11-page declaration with a small supplement. That was because things were filed after the fact. So what this is essentially my client consolidating everything. Now, the issue is because this was put on as a stay motion only a week ago, my client didn't have adequate time, which is why we got them so late. However, because that motion was shortened in time, my client needs the ability to respond to it, which is what he did.
Your Honor, can I briefly, I don't think we're on for a motion to stay today. We had stayed the ex parte order, but the ex parte order is what we're on here today. So we had stayed the relief that was granted pending today's hearing on the motion for immediate restraining order, which Mr. Diaz had filed.
So again, we had a lot of stuff come in today. So I've been trying to sort through this along with several other cases that came in today. What had occurred on this, and I know because I was the one who signed it, there was a request for an order shortening time. When I received that motion, and I'm just looking for it here, give me just a second. That was on April 2nd. That indicated that notice of that motion had been served on Ms. Winkles, which was part of the reason why, and essentially I signed an order shortening time to have the issue of whether or not the requirement to bring the child back, I stayed that requirement until we had a hearing today. That was based primarily on the fact that Ms. Powers got into the case, of course, familiar with the challenges both of these parties have with lawyers and everything. So that seemed to be appropriate, and that's the reason why that was done. So really where we're at today is whether or not the original order requiring her to bring the child back to Cowles County should be either reconsidered or something, essentially. So that's what I understand, kind of the status of where we're at, because there was an order already in place that required her to bring the child back, if I'm not mistaken.
You're correct, Your Honor.
Okay. And so what happened, again, Ms. Powers came in, said she just got into the case and was asking to have an opportunity to review that in court. That's why we're here, because the order was already entered. previously, and I simply stayed the effect of that order for a week.
That was my understanding as well.
So I'm trying to find that order. That was the order from, there's a lot of orders in this file. So give me, this is the one from 3/22, I believe.
Yes.
And Your Honor, we're also here to appoint a GAL. We were here several times. This is before Ms. Powers got in. One has been argued back and forth when Ms. Hawkins had other counsel, but we did select a name at the end, but it was never, I believe it just never went anywhere because of the UCCJA.
Right. There was a lot of wrangling back and forth. We did do the UCCJEA hearing, and that's been at least a few weeks ago. And then I think this is really the first time it's been back on for an actual hearing since that was done.
My client is in agreement with appointing a GAL. So if the clerk can give us the next 3 names, I think that that's at least an easy part in this hearing today.
Well, let's start with that. Who's our next 3?
Keith Lawrence,
Mr. Lawrence,
Lila Corey,
Ms. Corey,
Amy Turnbull.
and Ms. Turnbull.
I will strike Ms. Turnbull.
Okay.
I'm not going to make any strikes.
Okay, so that would leave us with Mr. Lawrence as the choice. Don't know if I think he is not on because he was on earlier for a request to reset. So we'll appoint him. Given the, excuse me, given what the court knows about these folks and their situation, at least pending further investigation into that, I'm going to do that at county expense for both parties.
Thank you. I would also ask the court to approve additional hours than GALs are usually given. As of the last reply declaration that made it to the clerk's file, the clerk has numbered that as pleading 123 in this file. And so it will take an unusual amount of time for the GAL to get up to speed. And the allegations are fairly significant from both parties.
And I'd agree.
All right. Are we normally doing 10 or are we doing initially? Do you know?
It's normally 10, Your Honor.
10. When we do this, I'm gonna initially approve 15. Mr. Lawrence can certainly request more if he needs it. I'm sure he'll be happy to do that. But I'll initially approve 15 as opposed to 10.
Thank you.
I think that's, given what I know about this case, I think that's very appropriate. And also knowing Mr. Lawrence, I expect he'll be able to get up to speed fairly quickly. See, as far as review dates, I guess I'd like to have an initial review on the 7th. I could do it in 2 weeks, but that may be a little tight.
I think I would prefer May 7th. That'll give Mr. Lawrence a little more time to get caught up and hopefully be able to provide some information.
Ms. Winkles, do you have a preference?
Yes, it depends on what we're doing in the meantime. It's just my client's obviously waited over 9 months at this point. That would be my only concern. I think Mr. Lawrence probably will need the time because this case is quite large. I think the week before that is judicial college, right? Okay. And in that case, 2 weeks will never be enough time. So I think May 9th is probably the best, but I would like to, my computer's about to die. I would like to do something. We've done the GAL, at least determine if mother has to bring the children back, if my client gets to start counseling with what's going to happen in the meantime.
I think and again, I'm probably as familiar with this case, and Ms. Powers, I know you've just gotten into it. I've been through a number of hearings and I'm very familiar with the allegations on both sides. They're significant. There's concerns going both ways. My thought would be is as part of your guardian ad litem order, I'm going to request you put in there that Mr. Lawrence give if possible, to give some sort of guidance as it regards to mom bringing the child or the child back to Washington, and what sort of contact should be happening on a temporary basis.
In that case, Your Honor, I'd ask for 2 weeks because we're just extending this more, even if it's just a mini review at that point where he determines that issue.
I'm fine with putting it on in 2 weeks, but I think Mr. Lawrence has the ability to, depending on how swamped he is, what else he's got going on, to probably give me something. It may be fairly limited, but because there's a lot of material. But I would suspect he'll be able to give me something in 2 weeks. And if he can't, then would set it over another 2 weeks.
That sounds good.
And I really would like to have something from, and again, there is so much information in this file, and I would be remiss if I told you that I thought I could tell you what I could find as far as factually on both sides of this case. It's just, there's just so much on both sides that I think having an objective investigator take a look at it is the only way I'm going to be able to make really any kind of a change of orders.
Okay.
So my thought would be is to leave status quo with the hold on the order, come back on the 23rd, and hopefully have some guidance from Mr. Lawrence. And I'll urge counsel to reach out to him and let him know that that should be in the order, but I would suggest getting maybe an email or a letter to him that there's a lot of material and would like to have something on those two issues specifically by the 23rd.
Okay. Does the court want to pick a date for his final report to be due?
Yeah, what are we normally doing on those for, are we doing 3 months?
Yes.
Okay, so that's going to April, May. That's going to be July. How about if we go to July 9th?
Your Honor, this is Beth Fellows, GAL, and I'm not sure if I heard you correct, but did you think that our normal amount of hours that we're paid for, like for private pay and or county pay, is 10 hours?
I guess I assumed that. Is that?
It's actually 22 hours.
Oh.
So I just wanted to let you know so then the GAL order is accurate.
If that's the standard order, then that's what it should be. And I think at 22, I'll probably let Mr. Lawrence request additional if he needs that.
Okay.
That was my error. Sorry about that. Thank you, Ms. Fellows.
Very welcome, Your Honor.
And should we go ahead and prepare an order and send it over ahead of time, see if we can get an agreed order so that it can get entered since we're doing a review so soon, or do you want to just present it on the 23rd?
I would like to get an order done so Mr. Lawrence knows what we're asking him to do. And I assume council could come to an agreement on those specific terms. It's just a standard GAL order otherwise.
Yeah, I'm happy to draft and I'll get the order to Ms. Winkles by the end of the day.
All right. Ms. Winkles, Ms. Winkles is having a problem here. Give me a sec. She got bumped out.
My apologies, Your Honor. I don't know what's going on with our internet.
We're having some challenges today, so it may not be just you. So what Ms. Powers is going to put together an order, get it to you by, I think, the end of today?
Yes.
Assuming that can be agreed, it can be submitted electronically and I'll get that entered. And that would be, I was in error. I thought we were smaller on our numbers. So it sounds like there's 22 hours initially. So I'll leave it at 22 at this point. That'll be sufficient to get Mr. Lawrence started. He certainly can let us know if he needs additional.
Thank you.
Thank you, Your Honor.
And then we'll review it in 2 weeks.
All right. Thank you.
Okay.
Does the court want an order leaving this all in place right now, or can the court enter a quick bench order?
The thing is, I think we don't need I don't think we need another order. The clerk's notes can indicate that there's a stay order in place until I make a different order.
Okay, thank you.
All right, thank you, Your Honor.
All right, so that I believe is our docket. We have a lot of folks online. I'm not sure if somebody else believes they have a case today. If not, we will be adjourning.